Take me through, Andrew, you go first. Take me through what this reveals to you that we didn't know before this section was unredacted.
Well, the thing that it makes really clear is why the government got a search warrant. To the extent that there was any question at the time, and certainly lots of people asked, why did they proceed this way? Although we had strong indications that they tried everything else, this makes it abundantly clear. As you mentioned, the orchestrated obstruction is laid out clearly with the former president and Walt Nauta basically trying to procure a false statement from Mr. Corcoran, the former president's then lawyer, and actually still a current lawyer for him, where he falsely certified that everything had been returned. And it turns out behind the scenes, the way that was orchestrated was Mr. Nauta and the former president were removing boxes and taking classified information out of them, and then returning some of those boxes so that Mr. Corcoran could say, oh, everything's been turned over. But Mr. Corcoran didn't, in fact, know about this whole orchestrated scheme. So I think that's sort of the key thing. The other thing, which I think is sort of a little bit inside baseball, is I think for people who are looking at this, if you read the newly sort of partially or further unredacted search warrant application, you really get to see the government at its best. It is setting forth not only what they know, but it's also making it clear to the court what they don't know, and also where there is so-called exculpatory or Brady information. And if you want to know what good government practice is, that's what it is. In other words, you don't just set out all of the proof that supports your position. You also make sure that the court knows what you don't know, which is they talked about exactly what they could see, for instance, and what they could not see. They also set out information that the former president asked them to make sure the court would know, which is the former president's claim that he declassified everything. That is set out in the affidavit that went to the judge. In other words, you really try and make sure that the judge understands the good and the bad. And it was really, I thought, very heartening to see that that is exactly what the government should be doing, and it's what they did do.
Okay, Andrew, let me go back to search warrants for dummies and ask you a less weedsy question. If so much of this sounds like a math problem, right? The newly unredacted material makes clear that more boxes came out than went in. If the behavior and the potential crimes are on tape, and I remember the New York Times reporting at the time that the government thought Walt Nauta was lying to them. Why did Walt Nauta lie when his behavior that was under criminal scrutiny was on tape?
So, I used to say this when I was prosecuting people where they were charged with committing a crime, and it was unbelievably stupid because they were going to get caught if the government did its homework. And I used to tell the jury, you know what the defendant's not accused of? He's not accused of being smart and thinking that he could get away with it. Lots of people commit crimes in ways that have them getting caught. Bank robbers go into banks, even though there's surveillance and people have cameras and take videos of them. Here, Donald Trump, for instance, has spent a lifetime, as we've talked about repeatedly, with no accountability. So he just thinks there'll be no repercussions. And so far, it's been right. Walt Nauta was being told what he had to do by his then boss, and still current boss. And he thought, that's what I'm going to do. And he hoped that he wouldn't get caught. Well, he did. And, to me, it's absolutely, the case against him now seems so clear because you have the statements that he made to the government saying that he really knew nothing about these boxes. And it's clear he knew everything about these boxes. So, the one thing that seems absolutely clear is that he is not thinking about this from a normal criminal perspective. He is thinking about, is it possible he gets a pardon? Is it possible that in the future his livelihood is going to depend on his allegiance to the former president? Because if you're only thinking this from a criminal perspective of could you go to jail, any good defense lawyer is going to read him the riot act about fact that in any normal case he would be convicted. The last count, which is about his lying to the FBI, just feels like a rock crusher. It's very hard. When you're a prosecutor, one of the things you do is you think about, how is this going to be defended? What will a defense lawyer do here? And it's very hard to see any sort of claim with respect to that count and how he's not going to be convicted of it.
I mean, Brendan Van Grack, I'm thinking of Mike Flynn pleading guilty to lying to the FBI. I mean, and Mike Flynn, of all people, should have had some familiarity with the evidence that would have been in the government's possession that would very quickly and easily prove that a lie. I mean, I know you have a very smart thread, and I'm sorry to pull you into search warrants for dummies here, but what is the profile of a Walt Nauta who had to have been aware of sort of the contours of the investigation before the general public was, had to have been aware of where the security cameras were, had to have been aware, and I mean, the texts are in the indictment of Trump asking him to get this and that and move it around in my box. I mean, how does he go in and lie at the same time that he's moving around different numbers of boxes?
Well, I think it shows the importance of when someone is charged with providing false statements or obstruction, it's not just the underlying criminal charge, it's what it means for the investigation. And in circumstances like this, why would someone lie? Why would someone risk criminal exposure for the reasons that you said, knowing that there could be videotapes or other information? Why would they lie? And if you're an investigator, if you're deciding, should I take this historic step to, for example, obtain a search warrant, when you don't, not just the surveillance information, when you have an aide, someone who you believe is aware and has knowledge of the relevant events, when they are willing to lie to you, when they are willing to risk imprisonment in order to provide this false information, then it forces you to change your posture. It's not something where you can now, for example, in this instance, simply rely on cooperation or someone's goodwill in order to obtain the information that you need.
Does it give you, I mean, it seems like we first learn about the surveillance footage in the first disclosure of the application for a search warrant, which I think was released under orders from the same judge. You have a smart thread about, what's new and and you've keyed in on some of the same things that Andrew has. But take me through what you learned from this newly unredacted material.
Yeah, well, I think there are two other pieces to layer on top of Andrew's insight. And I agree. I think the big takeaway is the clear justification for that historic step in August to search the former president's residence. But one piece is it really undermines this expected defense that these documents were declassified. One of the paragraphs that are now declassified is paragraph 60. And what it says is, when the former president's attorneys returned 38 classified documents in response to the subpoena, they never said that the documents were declassified. And I think that's something we generally expected, but this is the first time the government explicitly made that representation. And I think it's critical, not just that that statement wasn't omitted, that statement wasn't made, but when it wasn't made. If there was a time in this whole period, if there was ever a time to disclose that these documents were declassified, it was on June 3rd in response to that subpoena. This is, the former president was aware that there's a criminal investigation and the Department of Justice and FBI were asking for the classified documents. That is exactly the time when, if you believe these documents are declassified, that's when you would tell them that, hey, this isn't that big a deal. These documents have been declassified. We'll give them to you, but you can tone down the temperature. And the fact that those statements weren't made then, I think, is very telling. And I think it also shows that you're probably going to hear that from witnesses and from the Department of Justice in their case. The second piece is, I think it's really important to juxtapose this search warrant from the conduct of former Vice President Pence and his staff and President Biden and his staff when it came to the classified documents. In those instances, you had within 24 hours staff escalating when they identified classified information internally, and then externally bringing in the FBI and Department of Justice. Here, it's the juxtaposition is not just hiding these boxes from the Department of Justice and the FBI, but actually hiding them from the former president's own attorneys.
Let me come back to your second to last point about his, they were declassified. I had a standing order to declassify, which has been trotted out. I believe around this time, he does the Hannity interview at Mar-a-Lago, where he has this bizarre thing, I can declassify them by thinking them so. I mean, there are some public-facing proof points that some of which you're explaining may have been explained to the client by some of his attorneys. I mean, do you see sort of the carnage of attempts at getting Trump to stop endangering himself legally?
Well, ultimately, part of this is we're trying to get signals from these statements as what are the potential defenses. And I think even as Andrew just noted, in some instances, we just haven't seen what a defense could be. But I think the declassification defense is one that we have now seen from the beginning. I think, in fact, the search warrant talks about former staffers making some of those types of defenses on television. And again, I'd submit that if there was ever a time to disclose to the Department of Justice and to the U.S. government that these documents were classified, it was on June 3rd, before there had been a search warrant, before anyone was charged. Yeah. That's exactly the moment when you'd want to de-escalate.